Starting now, today is the 202 Friday group meeting. Today's meeting is in the two parts. Part 1 is a felicitation part. Part 2 is a sir lecture on PMLA arrest and bail. So recently, our members, those who addressed our Friday group in various last 9 years, they elevated as a senior advocate by this Honorable Supreme Court of India. We decided to hold felicitations to them. That is part 1. I think those bouquets will give through Justice Nagamuthu sir hands. So just now first come in Shobha Gupta. Please come. Now please come. It's not a classroom. Please come. Shobha Gupta addressed at our 135th Friday group meeting. That is the 6/12/2019. Rape and murder, speedy justice, etc. And another is 165th. That is 9 December 2022. So dichotomy, sexual between age clash and other thing. I mean, now Shobha Gupta, sir, please. I'll you with you, sir. Taken.
Thank you, sir.
Thank you very much, Shobha. You want to say anything? Few words? One or only few seconds.
So
not
thank
later.
you all of you. Sir said in that the message he sent, he said Midas touch. Alright? So that was actually Midas touch, and Midas touch of not only the group, the blessings and togetherness of all of us. And thank you all. Let us keep enjoying this Friday group. And 202 is a rifle also, so today is all the best. Thank you so much.
Thank you, Shobha. Now Karuna Nandi may come anytime. She's on the way. Now I request Napinai ji, NS Napinai ji, senior advocate recently designated. She addressed our 72nd Friday group meeting. That is on 16th February 2018. Second one is 113 Friday group meeting. That is 26 April 2019. And third is 149 Friday group meeting. That is on 20th May 2022. On everything is on cyber law. That is a technology loss decoded, peek into the cyber world, electronic evidence and cyber fraud, sir. Thank you very much. This is the only we can do little bit for you.
Thank you so much. Thank you so much, sir.
You can say few words, sir.
Very briefly,
Yeah.
thank you, Mr. G.Seshagiri Garu, because you introduced me not just to the Friday group, but to a large extent to the Supreme Court bar. So thank you for that. And all I would say is this is a beginning of yet another journey. So thank you all for having been part of the journey till now. And of course, I look forward to being part of your journeys and you being part of mine going forward. Thank you all so much.
Now I request our good friend Sridhar Kotaraju. Sridhar addressed our Friday group on 71 Friday group meeting. The topic was Uttarakhand High Court judgment declaring river Ganga and Yamuna juristic person. That is the first one. The second is 150th Friday, fifth Friday group meeting. That is on 26th August 2022. Indian maxims as a bridge between litigants and law. The third is 195th. That is the 10/11/2023 rejection of plaint. That's exactly order 7 rule 11 CPC. Thank you very much. All the best, Sridhar. Please, sir. Please.
Thank you, Seshu sir, for always being my mentor in this bar. When I joined in 1999, it's been 25 years of your mentorship. And thank you for the Friday group and all the members for giving me the opportunity to be here today as well as earlier occasions. And I look forward to be part of the Friday group's journey. Thank you.
How are you feeling this overall? This
This is overwhelming, sir.
Oh,
It's very overwhelming. Thank you very much.
Finally, sir, last Karuna Nandi is here. Finally, we catched her. She addressed our Friday group on 54th Friday group meeting. That is the 28th July 2017. The topic was transnational litigation and constitutional right insights from Bhopal cases. She is a very prominent lawyer in that. She argued and appeared regularly. Sir, now, Karuna, please.
Thank you so
Just
much.
you go.
and really telling also of the quality of the learning that we have here in this Friday group. The Friday group has been one of my intellectual homes since I was a fairly young lawyer actually. Justice Muralidhar had recommended that I join it when I was quite young. And it embodies one of my favorite things, not just about the Supreme Court but also about the law, which is the continual learning that we have from each other. So to be felicitated by this group and by Mr. Seshagiri Rao means double as much as any other. So thank you so much, and thank you.
Thank you, Karuna.
And Friday group will always get priority.
Today's topic is part 2 now. Arrest and bail in PMLA. Mr. Justice Nagamuthu, Senior Advocate, will speak now. Please, sir, you can.
Doctor to all of you. It is my pleasure again to stand before you to speak on a current topic which is confronting the bar the most. We know that there are two fundamental criminal jurisprudential principles in respect of arrest and bail. The first principle is that one may have the power to arrest, but it doesn't mean that in every case, invariably, you should resort to arrest. Is that bail is the rule and jail is an exception. Whether these two fundamental principles are still being followed and adhered to in the matters in the cases relating to PMLA Act, or there is any slight deviation from these fundamental principles, is a topic that I've been asked to today speak on. Look at section 19, whether it deviates from the other the fundamental principle which I have said about the power to arrest and exercise of such power. Let me read section 19 for our benefit. If the director or deputy director, assistant director or any other officer authorized in this behalf by the central government by general or special order has on the basis of material in his possession, please underscore these lines, on the basis of the material in his possession, number 1. 2. Reason to believe that any person has been guilty of an offence punishable under this act, he may arrest such person and shall as soon as may be inform him of grounds for such arrest. Two things are essential to exercise this power of arrest. Number 1 is that the officer who intends to arrest must have materials in his hand first. What are those materials? Material collected during the course of investigation by such as statements of witnesses recorded under section 50, documents recorded and various other materials. These are all the material which are to be collected first. So normally, if a case is registered under section 154 of CRPC by a police officer, station house officer, collection of evidence will take place after registration of the FIR. Arrest will also take place during that. Similarly here, instead of FIR, a case is registered known as ECIR, enforcement case. EC, enforcement case, information report. First information report is here known as ECIR. This is registered more or less equivalent to FIR, but since it is not registered by a police officer, because police officers have been completely excluded from the purview of this act in respect of PMLA offence. So The case is to be registered only by a director or assistant director or any officer who has been authorized, who will register ECIR. How ECIR can be registered? In CRPC, for a station house officer to register a case, some information making out a cognizable offence should be made to the officer. Based on that, he will register a case as directed by this honorable court in Lalita Kumari's case. So if he finds on perusal of the information furnished that there are materials to make out cognizable offence, then he will immediately register a case without having no other option. Of course, preliminary inquiry to be held is in certain exceptional cases. I do not want to go into those details. Now, whereas, so far as PMLA offence is concerned, ECIR can be registered only if predicate offence, an offence under any other enactment or IPC has been registered and is under investigation, and that offence involved, that we call it predicate offence, is an offence included in the schedule to the PMLA Act. In the schedule, there are several offences included. Even murder 302 is there, 307 is there. There are so many offences, 420 is there. So when such predicate offence has been committed, when FIR has been registered by the police and the investigation is going on, in that further predicate offence, the police officer may or may not decide to arrest the accused. That is one part. But on such FIR being registered, based on that, when information is shared to this director, assistant director, any other officer, he will register a case and as ECIR case for an offence punishable under section 4 as defined in section 3. On such a registration, he will start collecting, he will do investigation. The term investigation is also defined in this act. Investigation means collection of evidence. For what purpose? For two purposes. Collection of evidence for the purposes of preventing money laundering or to recover the money laundered by committing the offence or as a result of the commission of the offence. That is one part. For that purpose, now investigation materials can be used, and similarly, those materials collected by the officer concerned who has registered the ECIR who is investigating the case has to be satisfied. That is, he should have reasons to believe. From what? From those materials collected when after ECIR was registered. So first comes registration of the ECIR, second comes collection of materials, and third comes on the basis of the material so collected, the officer should have reasons to believe. This phrase plays a vital role because it has been interpreted under various enactments and in this act also by the Honorable Supreme Court in Vijay Madan Lal and in so many other cases. So this reason to believe should be recorded by the officer concerned. Once he records the reasons and also discloses the materials available for him to come to such a reasonable belief that he has committed the offence, then only he will resort to arrest the accused. One more thing also is there which is highly unnoticed, but he may have materials in a given case. He may have reason to believe that he has committed the offence. Does it mean that invariably in every case he has to arrest? No. For that, the general principle that unless it is so required, essentially required, to arrest the accused, arrest shall not be resorted to. We have got this Arnesh Kumar case which distinguishes the power of arrest and the exercise of the power of arrest. That case also highlights. Before that we have got the Niranjansi. The court says that because you are satisfied, because you have got reason to believe, don't resort to arrest in one mechanical fashion. But what is happening now in practice is that in every case where there are some materials in their possession that they collect, and there is also reasons recorded, immediately arrest is resorted to. After such arrest is made, the second part of section 19(1) comes into play, which says that the accused shall be furnished with the grounds of arrest. Now, what is material is how to communicate the grounds of arrest. It only says, you please kindly look at that, and shall as soon as may inform him of the grounds for such arrest. This provision has been dealt with in Vijay Mohan Lal, and the Honorable Supreme Court has not in that case gone into the issue as to whether such information is to be passed on orally or in writing. This question came up before a two-judge bench of this Honorable Court, where Honorable Justice Sanjay Kumar has authored a wonderful judgment, wherein he has said, that is Pankaj Pansal's case, His Lordship has very authoritatively held that the grounds of arrest in writing must be furnished to the accused as soon as the arrest is made. If grounds of arrest are not furnished to the accused, then according to His Lordship, the arrest itself is vitiated and therefore the petitioner is entitled to be set at liberty. In this judgment, His Lordship has given the reasons as to why this is insisted upon. When an accused is produced before the magistrate for remand, here before the special court, if it is IPC offence or any other offence, under section 167(2), when he is produced before the magistrate can remand the accused based on the case diary. Copy of the case diary must be produced before the magistrate. Based on that, if he is satisfied that further remand is required, he can remand, otherwise he cannot remand the accused at all. This is relating to section 167(2) in respect of IPC offences. Now coming to this act, what is produced at the time? Now the practice was that orally something will be said to him as to these are all the grounds upon which you are arresting. In the arrest order, they will get an acknowledgement also saying that I know the grounds of arrest. Then he will be produced before the magistrate. Now, before the special court. The special court, at the time of considering whether to remand him or not, to authorize the further detention or not, should have some materials. Now, what are the materials which are placed before him? Those materials which have been collected during investigation. But the accused has got no access to those documents. So he does not know anything about the material which are placed before the magistrate because copies are not furnished to him. So he does not know what are the materials collected which have prompted the officer to have reason to believe and to arrest. And what else is there for the accused to know? The accused is informed of the grounds of arrest orally. Suppose the grounds of arrest runs to several pages containing so many details. By simple reading out the same to the accused, can we expect him to know all these things so as to make out a case before the Honorable Special Court that look, these are the materials collected, this is the satisfaction, that is the reason to believe, that's what he says, and therefore this is not sufficient, therefore don't remand me to custody. This objection he has to raise. If nothing is there in his hands, neither ECIR is given, nor the material collected or furnished, even the grounds of arrest in writing is not given, then he will be completely in dark and therefore this will be only an empty formality at the time when he is produced for remand. He will have no say. He will say, I do not know anything. In order to overcome this only, His Lordship has held in Pankaj Bansal that you furnish grounds of arrest in writing, giving all the details to him. This is because in Vijay Madan Lal, the court has held that the accused is not entitled for a copy of ECIR at all. If it is FIR registered under section 154 CRPC, the accused is entitled for a copy of the FIR. But this court has held that copy cannot be furnished to you. When copy cannot be furnished, when the materials are not placed before the are not furnished to the accused, we will not be giving a fair inquiry at the time when he is produced for the purpose of remand. Therefore, this honorable court said that no, at the time of arrest, you furnish grounds of arrest in writing. Now, so far as the other things, material collected and the reasons recorded, belief recorded, and the arrest order, these things in original are not produced even before the special court. They are sent only to the adjudicating authority. That too in a sealed cover. That authority also won't open that. It is kept there in sealed cover. They won't open. So where is the accused now? Without knowing anything. That is the reason why in some quarters it is said that this is to some extent a draconian law, because no opportunity is afforded. Now this judgment in Pankaj Bansal, there is in paragraph 36, there is one word which says His Lordship has said that henceforth this procedure shall be followed by the authorities. This term henceforth was again interpreted before the High Courts, before a Delhi High Court, before Bombay High Court, and before the Punjab and Haryana High Court. This term henceforth was brought to the notice, and an argument was henceforth means in future, days to come. Therefore, in those cases where copy written, we have not been following the procedure of furnishing a copy of the grounds of arrest in writing, that is past, henceforth means in future, this we have to follow. Therefore, in respect of the case registered or where the accused are arrested before the date of judgment in Pankaj Bansal, this procedure cannot be looked into, and the judgment in a way is prospective overruling. This was the argument. A division bench of Punjab and Haryana High Court looked into paragraph more particularly about section 30, paragraph 36, and said that in the latter part, the Honorable Supreme Court has set aside the remand order holding that the arrest itself is vitiated on the ground that written grounds of arrest were not furnished. That in that case, arrest was made before the judgment date. Grounds were not furnished in writing before the judgment. The Honorable Supreme Court therefore held that you were not followed, therefore we are setting aside. This part was considered by the division bench of Punjab and Haryana High Court. Division bench held that the henceforth is nothing but a direction to follow scrupulously in future. But in respect to the past, if you are not already followed, then that vitiates the trial, and therefore he is entitled to be let off. In the same case, that is in Pankaj Bansal's brother, and he was let off by the Punjab and Haryana High Court. Bombay High Court took a different view. Then the matter came up before this Honorable Court. In this judgment, the Honorable Supreme Court, in Ram Kishore Arora, Directorate of Enforcement, Criminal Appeal number 3865 of 2023. This Honorable Court went into the issue. It's a different division bench. This division bench, two-member bench of the Honorable Supreme Court, here has declared that the intention behind the judgment while using the term henceforth means that this is to be followed in future in respect of the cases where the arrests were made before the date of judgment in Pankaj Bansal. This procedure cannot be the ground. Failure to furnish copy or grounds of arrest in writing shall not be a ground. So this is the field, this is the law that is holding today. So distinction is, in respect of past cases before the judgment, it is immaterial whether grounds of arrest in writing were given or not. there is no controversy that the grounds of arrest should be informed. On that, because the statute itself says there is concurrence by the courts. But whether the form, whether it is in writing or orally, in respect of past cases before the date of judgment in Bangaj Bansal, oral is enough. In the subsequent cases, in writing must be scrupulously followed. If not, the accused shall be set at liberty. So this is regarding the arrest. Then coming to, because you know,
Sir, we have sufficient time, sir, please.
I am calling the court, matter has been
Okay,
passed
matter,
over.
okay.
Matter has been passed over. So if you are pleased enough, I will cover, because this is a very important growing subject.
Correct, sir.
Regarding bail, I may need at least 1 hour, and if you permit me, I will do it on a different date.
Part 2 will make it, sir.
Yes.
Part 2 will.
Today I will confine myself only in respect of arrest alone. That's what I feel subject to.
No, please, sir.
Okay. So therefore, so far as arrest is concerned, I have said these are all the, this is the law today, as per this Ram Kishore Arora case. Now, there is yet another judgment of Honorable Justice Oka. Now, the Act says, whenever there is a predicate offence committed, in respect of which FIR has been registered or some other proceeding, criminal proceeding has been initiated, where investigation is going on, then ECIR can be registered, material can be collected, accused can be arrested. Now, if you look at the schedule, 120B is also included. I had a case where police registered a case under section 304A, reduced section 120B IPC. I do not know how such kind of FIR could be registered. 304A, negligence, rashness and negligence, that offence was committed by means of conspiracy. Then it must be murder or culpable homicide. They registered a case. Based on this, because there is 120B invoked in the FIR, ECIR was registered and the people are arrested in that case. Now, in this judgment, the judgment of Honorable Justice Oka, his lordship has held that 120B, though it is an independent offence, the conspired offence, which makes out the offence under section 120B, must be a scheduled offence. Suppose that is Pavanar Dibor, criminal appeal number 2779 of 2023, decided very recently. Beautiful judgment. Here in the case, 120B was invoked. There was yet another IPC offence for which conspiracy was hatched. Because 120B is there, ECR registered, everything goes on. His lordship said, otherwise, his lordship said that conspiracy which makes out an offence under section 120B IPC must be for committing a scheduled offence. So if the conspiracy is to commit a non-scheduled offence, though 120B is invoked in the FIR, you cannot register ECIR. If conspiracy is to commit a scheduled offence, for example, if there is a conspiracy to commit murder, then you can register 120B to commit a scheduled offence, therefore you can register ECIR, otherwise you cannot. Another example, suppose there is a case investigation going on with the Income Tax Act. If you look at the schedule, Income Tax Act, no offence under the Income Tax Act is a scheduled offence. But if suppose it is registered by the income tax authority, if they make a complaint to the court invoking section 120B, some 4 or 5 people, 120B is for the purpose of committing this offence, which is a non-scheduled offence. Can FIR be, can ECIR be registered? No. This judgment, in my concept view, is a wonderful, beautiful judgment and giving a full understanding to us of section 120B in the light of section in the light of the PMLA Act. This judgment also you should be aware of. These are all the matters where ECIR can be registered, who can register, and whether a copy is to be furnished to the accused or not, and whether the accused is entitled for any other document like material collected during investigation. These things are all now well covered by various judgments. Unless and until Vijay Madan Lal is reviewed by the bench on certain aspects, then this law will hold the field, and therefore what I have said in respect of arrest will be there in the holding the field. Now, they do the investigation, they arrest the accused, grounds of arrest are to be supplied. If not given, then the accused is entitled for bail. This provision came up for consideration before the Honorable Supreme Court in other case, that is Sundari's judgment. So I'll come to that. 1 second. Until yes, yes. Satyendra Kumar until versus CBI 2022 NACC page 51. Here again it has been reiterated that if the reasons for arrest are not recorded and forwarded, and if the first part of section 19(1) is not complied with, regarding the reasonable belief, etc., and also furnishing of copy, if not done, the accused is entitled for the benefit of bail. That judgment is also there in our favor. But despite all these judgments, now what is happening is that arrest is freely made, though no arrest is made in the predicate offence. This is going on. Now, let us assume that in the predicate offence, in the FIR, the accused is either discharged or the negative report is filed and it is accepted, or if the FIR itself is quashed, the entire case is quashed. What will happen to this ECIR which has been registered or ECIR complaint which has been filed before the court? What will happen? Vijay Madan Lal answers that. Vijay Madan Lal says that if once the FIR in respect to the predicate offence is quashed, or the case is quashed, or the case is in acquittal, or the accused is discharged in that case, you cannot proceed with the ECIR case. So the dichotomy is this. Now, investigation, the predicate offence is going on for years together. It's a very big scam. Let us assume it's a very big scam. Thousands and thousands of witnesses are to be examined. Police people are going on doing the investigation. Months together, years together, investigation is going on. There is no discharge, there is no quashing, nothing happens. Now, whereas this ECIR case is a very small case. In this case, cognizance is taken and trial goes on. In the trial, suppose the accused is convicted and later on in the predicate offence, that is in the FIR, either a negative report is filed or the accused is dropped or the entire case is quashed for some reason. What will happen to this punishment? What will happen to this punishment? This punishment is based on the judgment of the court. Where is the provision to nullify that judgment unless an appeal is filed? Let us assume that no appeal is filed by the accused. Then, though on one part it is said that a predicate offence has not been committed and therefore there is no proceeds of crime, arising out of the commission of that offence. That is a condition precedent for registering the ECIR. On one part, the accused is either acquitted or discharged so far as predicate offence is concerned. Suppose let us say that in that case it is held that no such offence was committed and there is no proceeds of crime at all. But in such an event, if already there is conviction here by the special court under the PMLA Act, what will happen to the punishment? Can we nullify it? Therefore, the law is to be so developed to say that the ECIR complaint trial should be stayed, but there is no provision in the Act. But the court itself should stay the proceedings. Or we have to move the Honorable High Court on 482 and seek an order of stay. That proceeding should be stayed, awaiting final outcome so far as the predicate offence is concerned, and subject to that, if he is convicted here, it is established that the predicate offence has been committed. And there, in that case, it will also be known that there was some proceeds of crime. Then there can be a trial commence in that case. But this is also not forwarded today to my knowledge, and this law has to be developed by somebody. Your great people are here. I only throw it to you for your kind consideration and make the law for the land. This one aspect we have to keep in mind regarding quashing, regarding discharge, regarding the acquittal of the accused in the predicate offence. Please kindly do that. Now, let us come this side. So far as the NDPS Act is concerned, there are officers who are appointed under section 53A of the NDPS Act. Those officers also have been empowered to arrest. Question was whether they are police officers and therefore any statement recorded by them under the NDPS Act are admissible in evidence. Suppose the accused gives a confession to the officer, whether it is admissible or not was the question. In Tofan Singh case, this honorable court held that they are not police officers, they are police officers for the purpose of section 25, and therefore any statement made by the accused to such an officer under section 53A confessing to the guilt is hit by section 25. Whereas here in Vijay Madan Lal, this honorable court has held that they are not even deemed to be police officers for the purpose of section 25 of the Evidence Act. And therefore, what is the net result? Any statement given by the accused under section 50 of the Act, he is bound to make a statement. That statement can be used against him. That by itself is a material to arrest the accused. Now, please kindly see. There, if a confession is made to the police, that can't be the basis even for arrest. But here, mere single statement recorded under section 50 from the accused, that by itself is a material to arrest the accused. So this is the position in respect of the arrest. Thank you so much.
One second, sir. Just. Thank you very much, sir. Very enlightening these things of PMLA is such a dangerous provision. You immediately accepted and so